Please be seated. All right, everyone, good afternoon. Oh, that is so slow. I didn't even hear half of you all. Good afternoon, everyone.
Judge.
Awesome. So you are here for jury selection, and I appreciate y'all waiting in the hallway. I want you to know that your wait in the hallway was not in any way related to this case. It's just that sometimes we have other cases that are on the docket and we need to take care of them before we move towards this. So you are in the 187th District Court. You're on the 4th floor and I'm Judge Boyd. What floor are we on? What's the court number? Who's the judge? All right, and you all are asking, why is she asking us this? We've been standing in the hallway. We know where we're supposed to be. The reason why I asked that of jurors is based upon my experience, because whenever we take a break and whenever anyone requests a break, everyone has to leave the courtroom. You can't say, well, I'll just wait here because I don't need a break. Everyone leaves. And it never fails that when people leave, people get lost. And we had somebody trying to get selected on another jury and they say, I looked up and everybody was gone. So if we ever take a break and you're lost, if you remember the 187th or if you remember Boyd, people will be able to direct you because this is the only 187 district court in all of Texas. And I'm the only Boyd at the courthouse. So now that I've introduced myself, to my left is the court reporter. The court reporter takes down everything that everyone is saying. Please speak at the tone that I'm speaking at so that she can hear. Now, this is what I want everyone to do. You have cards. You may be sitting on them. Please raise those cards. And do not lower those cards until I tell you to lower the cards. Whenever you have something you want to say, whenever somebody asks you a question and you want to respond to those questions, raise that card. Now, I'm going to ask you to do something for me now. Jurors 1 through 21, lower your cards. See, 75 was lowering. Only 1 through 21. If your hand is still raised, what that means is whenever you answer a question, I'm going to need you to stand to answer it so that the court reporter can hear. Is everybody able to do that? All right, I'm going to tell you right now, every jury that we've had, and we're usually in jury trial every week, every last one of those jurors has said, yes, we can do that. And every last jury has failed to do that. But I'm going to tell you what I told the last jury. I have faith that you will do that. If you see someone not doing it, just tap them on the shoulder, all right? You can lower your cards. To my left, these are interns, they're students. So they are here to observe and to learn. You will see people coming through this door. They're coming through that door for documents for me to sign. It has absolutely nothing to do with this case. When you see people coming through that door, they're coming through that door because they didn't read the sign that says, please do not come through this door. We're in the middle of jury selection. So with that being said, I'm going to have the parties introduce themselves for the state.
Good afternoon, everybody. I'm Brandon Craig, from the state of Texas.
My name's Lauren Espinoza and I also represent the state of Texas.
Defense.
I'm Leland McCray on behalf of Mr. James Ross.
Robert Porter. Good afternoon, ladies and gentlemen.
I'm James Ross, the defendant.
Right, everyone, please be seated. Now, what I'm going to tell you all is that everyone who is charged with a criminal case is entitled to be represented by defense attorneys. Sometimes you will have people who will say, I want to represent myself. In which case, when that happens, there's usually standby counsel that is still there to provide any advice if someone who's accused of a crime wants advice. Does everyone understand?
Yes.
So in the United States, people who are charged with criminal cases are entitled to attorneys. In this case, Mr. Ross has made the decision that he wants these two attorneys to complete the jury selection, which we call voir dire. And then after that, he may decide that he wants to proceed representing himself. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Ross if Mr. Ross decides that he wants to represent himself? Now, everyone who has a felony criminal case charge, they are brought to court by what's called an indictment. And an indictment is just a document, and that document is to tell someone what they're being charged with so they'll know. It would be a sad state of affairs if you're charged with an offense and everybody wants to keep it a secret and you don't know about it until you hear witnesses come in. So raise your card if you have ever had a traffic ticket. All right, now I will say something about this group. This is some of the worst drivers we've had. All right, you can lower your card. So I've had a traffic ticket before. It was when I was 19. So here I am, 21 years old. And it's just, you shouldn't laugh that hard. You should say, oh my gosh, she's super intelligent. So what ended up happening when I received my traffic ticket is you got pulled over. And that was back in the day where they just had paper with carbon paper and they write down what they're saying you did and they hand you a ticket. That when you are pulled over, and let's say hypothetically you're pulled over, and let's say they say you ran a stop sign. So the officer pulls you over, and I think now they have some kind of electronic device, and they print it off to you, they give it to you. When you accept that, you're not saying, yes, officer, you're correct, I ran a stop sign. That piece of paper is to let you know the officer is saying you ran a stop sign. This is where you need to go to answer for the officer's allegation, and usually that's on Frio Street. So an indictment is the same thing. An indictment is saying, this is what you're being accused of, and if you want a jury trial, this is where you need to be. But it is not evidence of guilt. It is not evidence of anything. It's just a piece of paper to give someone who's accused notice of what they're being accused of. Does everyone understand? So with an indictment, you're not allowed to hold that against anyone when they are here by an indictment. You are not allowed to consider that as any evidence whatsoever. Does everyone understand?
Yes.
Just think of the indictment as a document for someone who's accused. It's for them to review, for them to know what they're being accused of, but it's not to be considered by you in any way whatsoever. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Ross because he's here under indictment? Is there anyone here who's going to consider this indictment other than just a piece of paper to give him notice? All right, the next thing I want to talk to you about is hypotheticals, right? The state nor the defense, they're not allowed to tell you what they think the facts are in this case. You will only learn what the people think the facts are in this case if you're selected to be on the jury trial and evidence is presented. So when the state speaks to you, when the defense speaks to you, they're speaking to you in hypotheticals. So don't be like Mrs. Kravitz in Bewitched and say, oh, that's what this is about. No, it's not. You just listen to their hypotheticals. So you've watched Bewitched. Other people, I guess, they never watched it. All right. So the other thing I want to talk to you about is the charge in this case. So there are 4 counts. Count 1 is aggravated robbery. Count 2 is aggravated assault with a deadly weapon. Count 3 is aggravated assault with a deadly weapon. And count 4 is unlawful possession of a firearm by a felon. Now, in Texas, usually, and in this case, one of the ranges of punishment is always up to a $10,000 fine. That $10,000 fine, nobody knows where it goes really, but that's a range to consider, $10,000 fine. And then you have ranges of punishment. Sometimes your ranges of punishment in some cases may be 5 to 99 years or life in prison, maybe 2 to 20 years or life 2 to 20 years and up to a $10,000 fine, or 2 to 10 years and up to a $10,000 fine. As you can see, those are wide ranges of punishment. So for any first degree felonies, the range of punishment can be anywhere from 5 to 99 years or life. What does that really mean? That means that a person could be sentenced, if found guilty, 5, 6, 7, 8, 9, 10, 20, 30, 40, all the way up to life. Second-degree felonies, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. What does that mean? Somebody could be sentenced to 2, 3, 4, 5, 6, all the way up to 20. Third-degree felonies, 2 to 10 years. What does that mean? Somebody could be sentenced from 2, 3, 4, 5, 6, all the way up to 10, and all of it up to a $10,000 fine. Does everyone understand?
Yes.
Now, in some cases, depending on if someone is found guilty and what is or is not proven, a person could be eligible for probation. It just really depends. Does everyone understand?
Yes.
And in some cases, the ranges of punishment may end up being at a minimum of 25 years in prison, all the way up to life. So that's 25, 26, all the way up to life. Does everyone understand?
Yes.
Now, when we talk about ranges of punishment, people will say, well, I can't give this or I can't give this in a specific case. But it's not whether or not you can give a specific number if you were to find somebody guilty. The question is, can you internalize that that's the law? Is there anyone who will not be able to follow the law that those are the ranges, potential ranges of punishment? Then the question becomes, if you were to find somebody guilty, would you be able to take your knowledge of the range of punishment and any evidence that's presented to you and come to a decision on punishment? Does everyone understand?
Yes.
Is there anyone here who would not be able to do that? Now, the next thing I want to talk to you about is certain rights that people who are accused have. One is the right to remain silent. What does that really mean? That means that you don't have to testify if you don't want to testify. I've been a defense attorney. I've been a prosecutor. And let me just tell you, as a defense attorney, sometimes I would have clients and I would tell my client, you're nervous with me and I'm on your side. It's not a good thing that you can testify, right? Because sometimes people will say, oh, I know that person's not telling the truth because they can't look me in the eye or because they're sweating, these type of things. And then sometimes I would have clients, I would say the state hasn't proven their case. There's no reason for you to testify. And then sometimes I would have clients, they would have a speech impediment and they just were like, I really can't do it. So there are a host of reasons why people would exercise their right not to testify. Now, what I've discovered when I talk to the public, they will always say, well, if that was me, I want to tell my story. I hear that a lot. And I always chuckle inside because I'm like, that's not you. And that's not you with maybe an attorney who's advising you. Sometimes people don't consider attorneys in the same realm as doctors. But when you think of medical doctors give you advice, and usually you follow the medical doctor's advice. Well, it's the same thing with attorneys. They will give their clients advice, and sometimes they will follow the advice, sometimes they will not. But the key to the right to remain silent is, if Mr. Ross decides not to testify, is there anyone here who's going to hold that against him?
No.
Okay. Now, the next thing I want to talk to you is everyone who's charged with an offense is presumed to be innocent. What does that mean? If you're accused of a crime, you're presumed to be innocent. And guess what? The state has to prove your guilt beyond a reasonable doubt. They have to prove each and every element beyond a reasonable doubt. So in all cases in Bexar County, if you're charged with a case and you're being tried in Bexar County, guess what? The state has to prove that whatever they're saying happened in Bexar County. They have to prove an on or about date. So they have to prove every single element beyond a reasonable doubt. And if they fail to prove their case beyond a reasonable doubt, it doesn't matter if they fail to prove that it happened in Bexar County. If they fail to prove the on or about date, what should your verdict be? All right, so what should your verdict be?
Not guilty.
All right, so with the presumption of innocence, that basically cloaks the defendant, right? If the state is not able to prove their case beyond a reasonable doubt, then your answer should be not guilty. So right now, how much evidence have you heard about this case? So if you were asked to give your verdict at this point in time, what should it be? Okay. Now, I want to talk to you about fairness. What does fairness mean? Because people will say, are you biased? Can you be fair? This is what that means. Let's say you're coming down for jury duty and your plans are, you know what, I'm going to map it out because I know there's construction. I'm going to drive the night before. So you drive the night before so you can put in your plans. You get up super early the next morning and you come downstairs and your car is on cinder blocks. Somebody's taken your tires, they've broken into your vehicle, but you want to do your civic duty. So you say, you know what, I am still coming down to do my duty. And when you come down, you come either on via or by Lyft, or your next door neighbor brings you, and you're standing in line outside waiting to see what case you're going to get. And it's a criminal case. And when you come in, you're sitting down and a judge tells you, all right, we're here on a burglary of a vehicle. Attorneys will usually ask you at that point, you can't really be fair because your vehicle was just burglarized. That is really not the appropriate question. This is the appropriate question. Your vehicle was burglarized. You have been selected to be on a jury where somebody is accused of burglary of a vehicle. Are you going to say, you know what, my vehicle was burglarized. This person is accused of burglary of a vehicle. I really don't care. This person needs to be found guilty. I don't care what's presented. That's what it means by fairness, because all of us come with backgrounds. All of us come with maybe something that happened bad in our life. As I tell everybody, how many people, raise your card if you were born yesterday and you slept all last night. If you don't fit that category, that means that you have maybe have had some good things happen to you and some bad things happen to you. So in this case, the question is, will you, if you're selected to be on this jury, will you be able to listen to whatever evidence is presented to you and make a decision based upon the evidence that you're here, if you can come to a decision? Does everyone understand my question?
Yes.
Is there anyone who would be unable to do that? Okay. Now, the next thing I want to talk to you about, and I've already talked to you about ranges of punishment, but in Texas, there are two phases to a jury trial. People like to call it the innocence phase as phase one, but it's really not. The first phase of a jury trial is, did the state prove their case or not? If the state didn't prove their case, then somebody's not guilty and you don't have a phase two. If the state did prove their case, then the next phase is what's called the punishment phase. And briefly, could I have attorney's approach? All right, so if somebody is found guilty, then you have the next phase, which is called the punishment phase. In Texas, before a jury is selected, before we do this voir dire, anyone who's accused of a criminal offense must make a decision on if they were found guilty, would they go to the jury for punishment or to the court for punishment? And in this case, if they were going to the court for the punishment, it would be me, or they can make the decision to go to the jury for punishment, which would be whoever would be on this panel. So in this case, Mr. Ross has decided if he were found guilty, the jury would decide his punishment. Does everyone understand? And it's the law that he needs to make that decision before jury selection. Now, by making that decision, that doesn't mean he's saying he's guilty. It's just the law that he needs to make that decision. Is there anyone who's going to hold it against him for deciding that if he were found guilty, the jury is decide punishment? And I've already talked to you about the ranges of punishment. Next, I love languages. I think languages are beautiful. When I was in undergrad, grad school, and law school, there were some people who were from different countries. They spoke no less than 6 languages. Me, I'm not supposed to be in Texas. I'm originally from Louisiana. You can tell when I have to say words like oil and soul. I was not supposed to be here. I was supposed to be retired at 22. I'm supposed to be living in Paris. That's why I took French. When my friend Tanya was like, Stephanie, let's take Spanish together. And I'm like, I will never use it. Why should I take it? So I'm slowly learning it. but raise your card if English is not your first language. And just please keep your card raised until I call your number. So we have 12, 13, 20, 23, 31, 35, 43, 44, 47, 56, 70, and 75. And number 7, you have yours up as well? All right, 7. What is your first language?
Spanish.
Have you been able to understand everything?
Yes, yes, ma'am.
Thank you. Number 12, first language.
Spanish.
Have you been able to understand everything?
Today, yes.
All right, thank you. Number 13.
Spanish.
Have you been able to understand everything? All right. Number 20. First language. Have you been able to understand everything? All right, so everyone, I'm gonna need you to keep your voice up. Remember, Cindy has to take everything down. So you say yes? All right, thank you. 23. Have you been able to understand everything?
Yes.
Thank you. 31.
Yes. Spanish.
Okay, I still have faith in you guys. You can save us. All right, 31 in Spanish. Have you been able to understand everything? All right, 35.
Spanish.
Able to understand everything?
Yeah.
43.
Spanish.
And you've been able to understand everything? Thank you. 44. And have you been able to understand everything? All right, when you say not really, what do you mean? All right, so did you go to school here? All right, so how long have you been here? All right, thank you. 47. Have you been able to understand everything? Thank you. 56. Have you been able to understand everything? All right, I can pretty much say hurry up in every language, but I haven't learned it in Japanese. How do you say hurry up? It's so yay. All right, thank you. I'm going to add that to my repertoire. Number 70. Yes.
Spanish.
Have you been able to understand everything?
It's mostly hearing.
Hearing.
Yeah.
All right. If there's anytime someone can't hear, if you'll just point to your ear, we'll know that that's a sign that you can't hear, and we'll have everyone speak up. Thank you. 75.
Portuguese.
Have you been able to understand everything?
Yes, ma'am.
And how do you say hurry up in Portuguese? Thank you. All right, the next thing I'm going to talk to you is about travel arrangements and time constraints. It's expected that this trial will be concluded before Friday or at the latest by Friday. And that's Friday this week. And when we will start with testimony, that will be tomorrow at 1 p.m. So is there